Hey everybody, Ross Pitcoff here. I wanted to make a very brief video just to discuss the issue of public relations and litigation. Now, sometimes you might find that you wind up as a defendant, whether it's your company and you individually or just your company, is a defendant in a litigation. And especially when we're dealing with this, within the securities realm, we're dealing within the world of cryptocurrency and Bitcoin and tokenization, we wind up with a lot of litigation that comes out of it. So in those instances, a lot of the people that file these complaints can go ahead, go to court, and put together a lot of information above and beyond what's relevant for the litigation. So for example, they may try and go ahead and discuss your background or try and make things up about you that may not be fully false, but certainly aren't fully true, and they expand upon it just to create this idea of you being this very bad actor. And they essentially try and to go ahead and obliterate your reputation before you've even had an opportunity to answer the claims in the complaint. What I would suggest is, based upon the circumstances of your case, if you have a viable means of filing a motion to dismiss, you should do it. And the reason why is because in a motion to dismiss, you can go ahead and lay out an opening introduction, just as the plaintiff was able to do, and basically go ahead and refute a lot of those claims, but also really regurgitate or iterate back to the other party any issues that they may have to go ahead and show that, well, wait a minute, you're saying that I'm not so terrific, neither are you. But also, so if there's a viable means for a motion to dismiss, there is an opportunity to go ahead and get your storyline out there in your responsive papers. If you're answering and you really don't have a means for dismissal, if you have any counterclaims that you feel that you can go ahead and assert against the plaintiff, do it. Don't consider or delay or say, well, I don't know if I want to actually be countersuing. Usually when fire is thrown at you, you have to fight fire with fire. It doesn't mean that during this process you're not also working to try and reach a resolution, if that's something that's possible, but you need to fight, especially in the public eye. Very importantly, though, you're also going to want to seek PR. And what I mean by that is if a complaint is filed against you that essentially states a lot of falsehoods, makes it appear as if you're a very bad actor. If you're in an industry where people are going to be following that news and information, hire PR. Because a lot of times what you'll see happens is the plaintiff will have PR and articles will start coming out about the litigation that's going to affect your ability to conduct business unencumbered. Now, a lot of people will say, well, does that mean that there's defamation in the complaints? The difficulty and challenge is with complaints, typically a plaintiff is protected from claims of defamation simply because the courts wanted to allow a plaintiff to go to court and say what's true without having to worry about any negative consequences, such as a suit for defamation. So it's typically challenging to argue defamation when somebody files a complaint, though admittedly not impossible. But if you hire PR and you file either a motion to dismiss or you answer with counterclaims and you lay out your arguments, then there's always a very good chance that through public relations, you can sort of mend the detrimental and negative press you're getting with a lot of positive press that starts to focus on what you allege in your papers and throws it back to the other side. Something to consider. It's something I've seen before. Just wanted to make mention of it.